Call the case if call the case.
Yes, my lord. Thank you, my lord. Begin virtually today, Friday, the 27th day of February, 2026, before His Lordship, Honorable Justice Sanusi Kado presiding. Case number NICN CA14-2020 between Mr. Lawrence Okpa Oyi and Crossrock Industries Nigeria Limited. My lord, the parties are absent.
Appearance. Appearance. Appearance.
With profound respect, my lord.
Yes.
My lord, with profound respect.
Yes.
I am Chief N.O. Egwu. My lord, N.O. Egwu, as in E-G-W-U.
Yes.
My lord, I humbly appear for the defendant.
Any other appearance?
My lord,
No
my learned
appearance?
friend. My lord, my learned friend on the other side appears not to be online.
Okay. Registrar, have you notified them of the virtual sitting? Registrar. Victoria.
My lord, sorry, is the call that
Have you notified the claimants of the hearing of today's matter?
My lord, I did. I did.
I can't hear you. Talk loud. Yes, this is Mr. Ebu. Are you hearing?
Yes, my lord. My lord, I'm hearing you, sir.
Because I'm seeing you like you are having some challenges.
No, my lord, I am hearing you very clearly, sir.
Okay. In the absence of the way, since the claimants are not here, I will proceed with my judgment. This is the judgment
as
of
the court pleases.
But I will skip reading the preliminaries. That is that the complaint was instituted by the claimant, the facts of the case of the claimant. I will also skip reading. They have all been captured in the body of the judgment. I will also skip reading the case of the defendant. I will skip reading the submissions of counsel. Two issues were formulated by the defendant, which were adopted by the claimant. I have captured the issues and argument by the counsel on both sides. Then I now go straight to the judgment of the court. I have taken time to calmly read through the facts and evidence adduced by the parties. I have also taken time to scrutinize the several documents tendered and admitted in evidence. I have also considered the enlightening and weighty submissions of learned counsel for the parties, carefully noting the several decided cases relied on by them. Coming to the determination of the claim before the court, it has been established by a long line of decided cases that the burden of proof in civil cases like in the case at hand, rests on the claimant, that is he who asserts, has the burden of proving his assertion. The claimant here who has asserted being entitled to the relief sought is he that has the burden of proving his case by credible evidence. I have cited some cases in support. What emerges from the above cited cases is that burden of proof in civil cases is of two types. The first, which is termed as legal burden, is the ability of a claimant to ascertain positively, to establish and prove the entire or reasonable portion of his claim before the court, so that the court can give judgment in his favor. This is always constantly on the claimant. The other type of burden is that of particular facts or issues which a party claims exist. It is the burden of proof that oscillates between one party to the other party depending on the state of the evidence and pleading. While the first type of burden is called legal burden, the second is evidential burden. See the case of Bule versus Anfa Agute Cooperative Group Farming Society versus Nigerian Agricultural Corporation Cooperative Banks. From the six reliefs being sought by the claimant, reliefs 1 and 2 are for declarations. Reliefs 3, 4, and 5 and 6 are monetary in nature. They fall within the category of special damages, in which the law requires for them to be specially pleaded and particularized and strictly proved. Where a party claims special damages, the burden is on him to prove the special damages by credible evidence, most of the time by documentary evidence, which shows the actual loss he suffered. Furthermore, unchallenged ipse evidence is not enough to prove special damages, where the claim is required to be proved by documentary evidence. See the case of ATE and Co Limited versus Military Governor of Ogun State. See also Young versus Chebaran. See also the case of UBN versus Wanko. This means that special damages are such as the law will not infer from the nature of the act, because they are exceptional in their character and must be claimed specially and proved strictly. That's why special damages are such damages suffered by the claimant. This means that special damages are such as the law would not infer from the nature of the act, because they are exceptional in their character and must be claimed specifically and proved strictly. That's why special damages are such damages suffered by a claimant that is quantifiable in money worth. A damage is special in the sense that it is easily discernible and quantifiable. It should not rest on the plural conception of notion that would give rise to speculation, approximation, or estimate. In other words, when it comes to special damages, all losses claimed on every item must have crystallized in items and value before the court can grant. See Shodifo and Co. versus Daily Times. The Supreme Court has provided guidance on the strict proof. See the case of Onyiro versus Onyiro. In determining a case, court is enjoined by law to restrict its consideration to the case and the reliefs contained in the claims put forward before it. Put it differently, the court has no power to debate or jettison the claim of the claimant as adumbrated by the reliefs. In other words, the claim is determined by the reliefs being sought. See Gabriel Atibi versus Kabel Metal Nigeria Limited, where the Supreme Court has this to say: a claim is circumscribed by the relief sought. The duty of a plaintiff, therefore, is to plead only those facts and materials as are necessary to sustain the reliefs and adduce evidence to prove same. He may, at the end of the day, obtain all the reliefs claimed or less. He never get more, nor does he obtain reliefs not claimed. A court is therefore bound to grant only the reliefs claimed. It cannot grant reliefs not claimed. In line with the above dictum, this court, in determining the case of the claimant will be guided by the relief sought. In the circumstance, I shall now consider the relief sought by the claimant vis-a-vis the evidence adduced before the court so as to see whether the claimant counsel, I didn't know what happened. It went off. So I will continue from where I stopped. I shall now consider the reliefs sought by the claimant vis-a-vis the evidence adduced before the court so as to see whether the claimant has justified granting of any of the reliefs. Relief 1 and 2 are for declarations. It is well settled law that the court does not make a declaration of right either on admission or default of pleading. It must be satisfied by evidence laid by the party seeking for declaration. If the party fails to establish its entitlement to the declaration sought by his own evidence, the declaratory relief will not be granted. Even on admission by the defendant, a declaratory relief will be granted where the party asking for it is entitled to the relief to the fullest in the meaning of the word. Declaratory reliefs are not granted as a matter of course on a platter of gold. They are only granted where credible evidence has been laid by the claimant or person seeking the declaration. See the case of CPC versus INEC. See also the case of Matami and others versus Dada. See also Chukuma versus Shell Petroleum. See Anayo versus Mandilas and host of other cases cited therein. It is beyond succeed or fail, irrespective of declaratory release on the strength of his own case. By law, a claimant seeking for declaratory relief must prove his case on the strength of his evidence, not on the weakness of the defendant or defense. See Okereke versus Umahi. See also Nisomuke versus Peter Side. And a declaratory relief is never granted on the basis of admission or default of pleading. See Bullet International Nigeria Limited versus Omonike Olani. The vital question to be answered is, have the claimant in this case been able, by the evidence above in the statement of facts, cogent and credible in proof of claim before the court? In this case, the claimant has to succeed or fail on the strength of his own case and not on the weakness of the defense or even admission. This is because the burden of proof on declaratory release on the claimant is heavy one, in the sense that such declaratory release is not granted even on admission of the defendant where the claimant fails to establish his entitlement to the declaration by his own evidence. This means the declaration sought by the claimant in this case cannot be granted on admission or in default of defense. See the case of Bello versus Iweka, Mutuanshe versus Shorobe, Chukuma versus Shell Petroleum, Kafo, and another versus Samori, where a declaratory relief is sought, it is to declare as establishing legal and factual state of affairs in respect of the course of action. Thus, the court will not readily, without good and sufficient evidence, exercise its discretion to grant a declaratory order. The party seeking for declaration is calling to court to confirm state of affairs, what is agreed or likely to be in connection with the subject matter of the declaration. It is, in this case, the claimant places reliance on exhibit 1, 2, 1, 3, 4, 5, 6A and 6B in proof of declarations. This exhibit clearly have established with the defendant. The claimant also placed reliance on exhibit 11, 12, 13, 14A, 14B, and 15 to show that he was forced to go on administrative leave and on stood of which action are not supported by the terms and conditions of employment. The claimant have also put himself on 50% salary, and the latter suspended his salary, all entitlements, security, and other domestic allowances. However, there are no better issued terminating his appointment, his employment, and other. This shows that the claimant is still in the service of the defendant. Exhibit 11 and 13, which placed the claimant on administrative leave and stood off, have not been backed. Exhibit 11, which has put the claimant on administrative leave, has not been backed off by the agreement of the parties, while stood off have backing from the agreement of the parties as it has been provided in the conditions of service. I have carefully examined Exhibit 2, the condition of service. There is nothing therein authorizing the defendant to place claimant on administrative leave, but he can be placed on stood up as was done in this case. There is also no provision authorizing suspension of claimants suspension of salary ad infinitum. Under the Nigerian labor jurisprudence in employment relationship where parties have written terms of employment, they are bound by the terms of the agreement, and none of them will be allowed to jettison the agreement or import extraneous terms into the agreement. The law is settled that parties are bound by the agreement. To put the Latin phraseology in full, facta convent co neba contra legis negu dualo molo initia, which means contracts that have been entered neither illegally nor with fraud must in all respects be observed, or facta dent legend contractui, meaning agreement give law to the contract. The employer's power to suspend an employee is generally derived from either express contractual provisions of employment contract or conditions of service, or in limited circumstances from the employee's inherent disciplinary power. Where no such provision exists, administrative suspension without pay becomes legally problematic. In the case at hand, no provision exists in the contract of employment or conditions of service that empower the defendant to place the claimant on administrative leave as per Exhibit 11, but there is provision for stood down as per Exhibit 12. The mere fact that employer has right to terminate does not give him blanket check to do whatever he likes on the basis of the extant terms of the contract. The agreement must be respected since the contract employment and conditions of service make no provisions for administrative suspension. Such action of the dependent in this case is ultra biased. It has gone beyond the employer's power and therefore unlawful, while the phrase stood up is a commonly used in employment practice and industrial relation to refer to a situation where an employer, particularly where an employer temporarily removes an employee from active duty, obtain pending resolution of certain organizational matters. Therefore, stood up is contemporary layoff, removal from work, removal from duties, and removal due to economic or operational reasons. It also cannot removing the employee from active duty and withholding his conviction. Therefore, stood up is a temporary layoff, removal from work, removal from duties due to economic or operational reason. It also cannot removing the employee from active duty and withholding remuneration. However, the concept of stood up is not formally defined in the Nigerian law. Its legality and enforceability must depend on the agreement of the parties or making provision for it in the conditions of service. In the case at hand, there is provision made in the condition of service exhibit 2. Therefore, for any form of suspension, standing up or removal from active duty must be expressly authorized by the employment contract or conditions of service. Without such provision, the employer in this case, there is no provision made in Exhibit 2 empowering or authorizing the dependent to place the claimant on administrative leave and stood up. This means the placement of the he is also entitled to full salary and benefit as the employment relationship has not been lawfully terminated. The claimant is as well entitled to recover his unpaid wages. See the case of Goldie versus Ekasa Aluminium and Company Nigeria Limited, where the Court of Appeal held that where an employee has not been formally terminated and remains ready and willing to work, the employee is entitled Similarly, in Dr. Ben Chukuma versus Shell Petroleum Limited, the Supreme Court ruled that any attempt to remove an employee from service without compliance with contractual notice requirement or payment in lieu of notice as pointed out earlier in this judgment, Relief 3 being monetary in nature is a claim for special damages, which in law must be specifically pleaded, particularized, and strictly proved by the See also 7-Up Bottling Company Nigeria Limited versus Agosto, NNPC versus Kilepo Nigeria Limited, where a claimant fails. This says the claim must fail Additionally, in the case of Surajo Rufai versus Bureau of Public Enterprises, the judgment of which was delivered on 4th day of June 2018, this court has this to say: in labor relation, the burden is on the claimant who claim monetary sums to prove that not only entitlement to the sum, but how he came about the quantum of the sum. And proof of entitlement is often made by reference to an instrument or document that grants it, and not oral testimony of the claimant, except if corroborated by some other credible evidence. In fact, by the decision in the case of Mr. Joseph Akinola and others, La Farge Cement Company, the Court of Appeal had specifically cautioned against reliance on oral evidence as proof of such entitlement. The claim in Relief 3 are divided into A, B, C, D, E, F, and A, F, G, and H. I shall consider them one by one. Relief 3A is for outstanding salary from March 2017 to March 2020. This claim was further There is no dispute that by the Exhibit 13, the defendant suspended claimant salary with effect from March 2017. This suspension of salary continued till date unabated. The defendant is suspending claimant salary with effect from March. There is no provision in the condition of service for indefinite suspension, withholding of an employee's salary. This means the action of the defendant in unilaterally suspending claimant's salary ad infinitum is ultra vires, illegal, and unlawful. The foundational principle in law is that an employee is entitled The foundational principle in law is that an employee is entitled to remuneration for services rendered or for a period when the employee remains ready and willing to work, as in this case, but no work was provided to him. Since of Gold Yakasa versus Aluminium Smelter Company, the Court of Appeal addressed the issue of employers withholding salaries without justification. The court held that where an employee has not been formally terminated and no lawful suspension order has been communicated to the employee remains entitled to all salaries, allowances, and emolument. This is the situation the claimant found himself, his salary suspended ad infinitum. This means indefinite suspension. This means the indefinite suspension of the claimant's salary without contractual or legal basis constitute breach of the employment contract. In law, an employer cannot lawfully suspend an employee's salary indefinitely. Such action amount to breach of contract. Such action amount to breach of contract. It also violates employees' fundamental right to dignity of labor and likelihood and livelihood. Consequently, the claimant is entitled to recover his suspended salaries. An employee whose salary has been unlawfully once employment has not been formally terminated, an employee is entitled to claim for salaries. It is important to note, however, in master and servant relationship like the one under consideration, generally do not grant or reinstatement orders in employment contract except in employment with statutory labor. Having It is important to note, however, in master-servant relationship like the one at hand, court does not grant specific performance of reinstatement order in employment contract except in employment with statutory labor. Having found that claimant is entitled to recover his salary, and the next issue to be considered is the amount as per his claim, whether he has proved entitlement to the sum of 7,776,000 naira. The claimant in calculating used exhibits 7A and 7B, which shows his gross salary to be the sum of 216 naira. He multiplied it by 36 and it brought the figure to 776. However, the claimant was wrong to use gross income. What he is entitled to is net salary and not the claimant was wrong to use gross income. What he is entitled to is the net pay, which is 176,894 naira 33 kobo. If this amount is multiplied by 36, then the total amount will amount to that 6.7 million. I now turn to claim. In this case, the claimant ought to have used the claimant what he is entitled to as per his salary is his net pay, which is 178,894 naira 33 kobo. If this amount is multiplied by 36 a month, which is for the period of claim, the amount will come to 6,440,188 naira 68 kobo. I now turn to claim of 900,000 leave allowances for year 2016-2020 to year 2020. The defense of the defendant is that claimant did not work as from the day he was placed on administrative leave and stood up by the Article 9 of Exhibit 2, Condition of Service. Claimant is entitled to leave allowance per year per equivalent to 1 month. Basic salary as per Exhibit 12, claimant salary and allowances were suspended effective March 2017 till further notice. I have found the suspension of the claimant to be ultra biased. In the circumstances, claimant is entitled to leave allowance for the period of his claim. As the Court of Appeal in the case of Goldie Ekasa Supra has on the claim for long service, I agree with the defendant. This claim is discretionary and for it to be granted, the party seeking it to be granted must convince the court of his entitlement to these particular reliefs. On transport allowance, it was provided for in Article 11, Section 2, subsection B, by the provisions of condition of service, the claimant is entitled to transport allowance of 5% of his basic salary, which is 9,000 naira. Multiplied by 48, it will amount to 9. On transport allowance, it was provided, which is 5%. 5% will be 9,000 multiplied by 48. It will bring the total amount to 432,000 naira. Medical expenses, the claimant is claiming the sum of 155,305 as medical expenses. In support, he tendered Exhibit 20. Article 12 made provisions for payment of treatment of employee in case of an accident and the employee was rushed to the hospital. Apart from Exhibit 20, receipt of medication, there is no any other evidence adduced to establish that there was an accident involving the claimant and he was rushed to the hospital and he is to pay the bill of the hospital. The claimant has also claimed for domestic allowance. The claimants improve of this relief tendered evidences in Exhibit 17, 16, 17, 18, and 19. I have thoroughly examined Exhibit 2, condition of service, and could not lay my hand on any provisions where these items were arrested. On domestic allowance and utility bill, the claimant improved tendered exhibits 16, 17, 18, and 19. I have thoroughly examined Exhibit 2, condition of service, and could not lay my hand on any provisions where these items were stated as entitlement of employee. In the absence of any document establishing granting domestic allowance and utility bills, the claimant fails in his duty of proof, and in the circumstances, these reliefs are hereby discountenanced. Relief 4 is for reinstatement, or in the alternative, an order directing payment of all financial entitlement, namely 1 month salary in lieu of notice, salary and allowances from purported date of suspension to date, terminal benefit of 750, ex gratia given after service. Let me say that the law is settled for reinstatement is not grantable in master and servant relationship, as court does not enforce employee on unwilling employer. For the alternative reliefs, 1 month salary in lieu of notice, it is grantable and I hereby grant it. The claimant shall be paid 1 month salary in lieu of notice. For salaries and allowances, from date of suspension to date is begged, is not grantable. See the case of Dr. Ikwe Goha versus University of Jos, whereby this kind of relief was considered to be begged and on terminal benefit in the sum of 750,000. This benefit is provided in Article 5, Section 4. The main claim entitled to is having served the dependent for 20 years. Ex gratia gift could not be found for ex gratia gift. I could not find any provision in the Exhibit 2 conditions of service that grant this entitlement to employees. In the absence of any evidence on the gratia gifts, I hereby dismiss the claim on ex gratia payment. I now turn to Relief 5, which is for undertaking of treatment of claimant's eye, payment of 100 million naira to handle expenses arising from the treatment of the said eye. I have carefully considered this relief. For this relief to be granted, the claimant must prove by adducing credible, admissible evidence. As it is now, it has for this relief to be granted, claimant must prove by adducing credible, admissible evidence. As it is now, it is bare. There is no iota of evidence to grant this claim, as there is no evidence from any medical doctor on the diagnosis or tests conducted on the problems of the eye of the claimant. There is also no evidence showing essential cost, showing the cost of treatment as per the diagnosis made from the hospital or doctor who is to conduct the operation. The claimant has woefully failed to prove entitlement to this claim. Same is hereby refused and dismissed. On Relief 6, which is the last relief, is for 50 million, being exemplary and general damages for the unlawful act of the claimant. I have from my consideration of the facts and evidences, it is clear to me that there is no evidence to prove entitlement to exemplary damages for an unlawful act of the defendant. However, the claimant will be entitled to some damages having partially proved his case. From all I have been saying above, the claimant in this case has succeeded in fact in proving his case and has failed in some respect. In the circumstances, for avoidance of doubts and clarity, I hereby make the following orders. 1. The claimant is entitled to unpaid salary from March 2017 as per his claim. However, due to the fact that the claim was calculated based on gross pay, that cannot stand, but the claimant is entitled to benefit based on net pay, and the amount the claimant is entitled to is 6,440,000 naira. In the circumstances, I hereby award the sum of 6,440,000 as the claimant's unpaid salary from the date of suspension to 2020. The claimant has as well proved entitlement to leave allowances, and he is entitled to his claim of leave allowances in the sum of 900,000 naira. Same is hereby granted. The dependent is hereby ordered to pay the said sum to the claimant on the terminal benefit in the sum of 750. The conditions of service exhibit 2 article 5 section 4 is very clear and unambiguous that the claimant is entitled to 750,000 naira as his terminal benefit for serving the dependent for 20 years. However, there is claim that he has applied for payment in advance of the sum of 300,000 naira was approved as part of his gratuity. It is to be noted that gratuity is payment that is made after leaving service. It's not paid while an employee is still in service, in active service. So what was paid to the claimant, the sum of 300,000 naira, cannot and will never be gratuity as far as gratuity is concerned, because it was not granted after the claimant has ended his service with the defendant. In the circumstances, the claimant is entitled to his 750 as terminal benefit. The claimant has not proved entitlement to 100 million regarding his eyes problem. He has not also been able to adduce convincing evidence for the court to order treatment to be made. For this relief to be granted, the claimant must prove or adducing evidence showing how there is no doctor's report, no any person in the medical field that testified to convince the court to establish that he is entitled to 100 million. There was nothing submitted to show how the 100,000 was arrived at. In the circumstances, it is a conjecture and speculation by the claimant. Same fail, and I hereby refuse it. For the 50 million naira exemplary and general damages, under the Nigerian law, a successful party is entitled to some compensation as cost follow event. In the circumstances, I award 300,000 naira as cost to the claimant. All monetary sums concerning this judgment must be settled within 30 days from today, the date of this judgment. On exemplary damages, there is no evidence before the court to establish entitlement of such reliefs by the claimant's witness. As exemplary damages is a punitive damages that is usually granted to serve as deterrence. From all I have been saying above, the claimant succeed partially, and the reliefs he was able to prove are hereby granted as per the orders of the court. Judgment is hereby entered accordingly.
As the court pleases.
My Lord, with respect.
Yes. Yes. Counsel, you have muted yourself.
Hello, my Lord. My Lord,
Yes.
we are very grateful. We thank you for the judgment.
Yes.
Lord, we only humbly pray, my Lord, to make an order that the judgment be made available to the defendant within 7 days, sir.
Yes, it will be made available to you before 7 days.
We are grateful, sir.
You are welcome. Thank you, counsel. We have come to the end of today's proceeding.
We are grateful, sir. Thank you.
Yes, yes. Thank you.
Chris, I'm here, but I was taking a virtual judgment. Industrial.
We will add some what that is.